Okay, we're going to try this one more time. We're live for the second time this morning.
Good morning.
Little technical difficulties to get us started off. That's okay. Everything, as we will learn today, discussing businesses and divorce, sometimes everything is a learning experience and you don't know what you don't know. We found out something we didn't know this morning. So, to keep us rolling, your off-air voice in the sky is Allison Frazier. I'm the Communications Director at Sodoma Law. You are joining us for our first ever Family Law Academy webinar, and today we will be discussing divorce in your business. Sodoma Law is a family-focused and family-driven law firm with practice areas in family law, business litigation, employment law, and estates, wills, and trusts. Today, moderating for us is going to be family law attorney Petra Center. Petra is licensed to practice family law in both North and South Carolina. Joining Petra today are presenters family law attorney Teresa Vieira and business and commercial litigation attorney John Woodman. Just a little housekeeping before we get started. If you have any questions during the presentation, please type them into the chat box on the right of your screen. Petra will bring them up as appropriate during the presentation. We will also have time for questions at the end. If you're on Twitter and would like to interact with us live, you can find us at Sodoma Law and at the hashtag the Sodoma Way. If your question is not answered today, someone will follow up with you after the webinar. This session is being recorded and you'll also be able to stream it on the Sodoma Law website and through our YouTube channel. Now, without further ado, I'm going to turn it over to Petra, John, and Teresa.
Thanks, Allison, for that introduction. It's great to be speaking with you all today about the intersection of family law and business law. And so we found, we have this great opportunity to work with lawyers that do different things here at Sodoma Law. And a lot of times we find that there are some cross sections of what we do, with John doing business litigation and we handle family law. Sometimes those things intersect in different ways, and we find different ways to collaborate and draw on experiences and information that the other attorneys have. And so to get us started off here, I think we want to look at a couple different scenarios for people who are looking at starting a business or purchasing a business. And I know maybe a little bit of a unique circumstance, but let's start with you, John. Like in a situation where we have someone who's looking at forming a new business entity or purchasing a business that already exists. What are the steps in that process that you would take that individual through? And then we're going to have Teresa kind of chime in after that and talk about that same person who's maybe looking to get married.
Definitely. So at the initial consultation meeting with the client or the entrepreneur, the first thing that we want to figure out is, what is the purpose of the business? The purpose of the business will define very quickly what formation is most likely best. Formation meaning it could be a corporation, a S Corp or a C Corp, could be a partnership, or it could be a limited liability company. Based upon that purpose of the business, that's going to gear and structure which corporate formality is the best. On top of all of that, there's tax consequences and tax issues that need to be addressed with the entrepreneur's accountant as well. And then once we are able to hone down on which corporate formation is the choice that's going to work best for the business, then we can start steering the ship in the right direction and be able to get them going so they can start operating.
And can you identify just a couple of quick pitfalls of maybe not doing those things when you're structuring the business, or making the wrong election, or thinking that you can kind of handle that on your own?
Yep. So I'm sure, as you guys see, people love their stuff, right? And that's kind of what happens at the end, and we can get to that later, obviously. But failing to follow the corporate formations, or even creating a corporate veil for yourself, can hinder the opportunity for you to protect your personal assets. As you continue to do business with certain creditors and vendors, if you don't have that corporate formation set up properly, or even not at all, then those creditors can come looking after your personal assets that have nothing to do with the business. So it's important at the outset to get a business attorney to set up the corporation properly, choose the proper corporate formation, and you'll obviously have a better likelihood of being able to keep the business and the personal assets separate.
Okay, thank you for that. Now, Teresa, let's think about this same potential client who's talking with John about handling the structure of the business in the right way. Let's just say that maybe they have a lot of things going on in their lives and they're looking at the possibility of getting married. So on the front end of that, prior to the marriage and looking at structuring a business, what are some things that you might advise that particular client from the family law perspective?
Well, from my perspective, I would recommend that they look into drafting a prenuptial agreement. It's also referred to as a premarital agreement. And this type of agreement basically contemplates what will happen to all of the property, specifically a business, should a divorce incur after marriage takes place. Now, it is an agreement that should be established prior to the date of marriage. I would say at least a month before the date of marriage to make sure it is enforceable, but it will contemplate what will happen to the business, how it's divided, how it will operate should a separation occur.
Okay, and are some of these things already defined in the statute? Or what might be the reason for trying to have an agreement about it prior to the marriage?
Well, I always tell my prospective clients that if you do not decide what will happen to your property, someone else will. More specifically, the the divorce laws will define what will happen to your property and your business if you do not agree upon it. There are specific laws that apply to property distribution in North Carolina. It's called equitable distribution. And as it relates to a business, if the business was created, say, before the date of marriage, that business may still be the separate property of the owner of the business. However, a marital interest could develop if there is any active participation by the other spouse to increase the value of the business. Vice versa, if a business is created after the date of marriage, then that business itself is marital property regardless of who is the listed owner or stock owner of that business.
And what do you think as far as how prenuptial agreements or premarital agreements have been looked at maybe up to this point? Do you think maybe they've gotten a little bit of a bad stigma?
Definitely. Up to this point, they've been more of a taboo type of agreement. It's usually viewed by either society or one spouse as, well, okay, you're already thinking that we're going to get divorced. You're not thinking that we're going to last forever.
We can thank TMZ for that.
Yeah, exactly. And that there's no trust. And I would like to remind my clients, though, that a premarital agreement is a form of insurance. Similar to if you get car insurance, you don't suddenly think, okay, I'm going to hit every mailbox down the street and get into an accident. Or if I get health insurance, I'm going to expose myself to malaria. It's similar to that. A premarital agreement really is a type of insurance should the inevitable happen due to no fault of either spouse at times.
Teresa, you mentioned something earlier about growth in a company. Obviously, having a business to turn you through the growth aspect is a vital piece of having a successful business. But you talked about how the premarital or prenuptial agreement can handle the growth of the company. Should, for example, I set up a business prior to marriage, I put in 5 years of sweat equity, and then 10 years later, it's tripled in value. How could the premarital prenuptial agreement handle that, if at all?
Well, the premarital agreement or prenup will go ahead and define who will retain that increase in value. If, for example, one spouse says, I'm going to do all the work in creating this business, forming the business, and the other spouse basically states, oh, I don't want anything to do with that business, we can put in the premarital agreement that one spouse have as his or her sole and separate property any increase in value to the business. Now, on the same flip side, if both spouses agree that they both want to be involved and they want to be equally involved, we can say from the outset, all increase in value is going to be divided equally 50-50. Unfortunately, if you don't decide it beforehand, though, a judge very well can find very differently in the courtroom.
And it really is a matter of tailoring it to what the client wants to do at that time. And it doesn't mean that it couldn't be changed later if both parties agreed, but it's a way to define those things maybe when you're on better terms and you have a clearer picture and maybe not going through some of the turmoil associated with the separation.
Yeah, and actually that's a great point because a lot of people think if a premarital agreement is signed before the date of marriage, you can never change it. In fact, you actually can change it. There is some formality associated with adjusting the premarital agreement, but if the spouses decide to change it in the future, they can.
Okay, and we talked, John, you were alluding to this a little bit about well checks along the way with the business. So from your perspective, once the business is structured, what are those well check points along the way?
So first and foremost is making sure that they're following the constitution of the company. So if it's a limited liability company, an operating agreement. If it's a C Corp, S Corp, the shareholder agreement, partnership agreement, making sure that they're following what's to occur and what's outlined in that agreement that they've negotiated. So that's first and foremost. Another thing that I see that kind of creeps up on my business clients is taxes. You're not getting a bill from the IRS on a regular basis like you would your trade vendors, making sure that they're withholding the proper payroll or the sales tax, because once you get behind on those are, it's like an avalanche. It just keeps going bigger and bigger and bigger. And then just making sure that they continue to monitor their employee handbook, how the employee laws change, making sure that they are paying their debts when they come due. Those are kind of just checkpoints that I like to do with my clients on maybe once every 3 months, 6 months, depending on the size of the business. Obviously, if it's a bigger business, they might have in-house counsel or they may have out-house counsel just on a retainer where they can bounce questions off on a regular basis.
Okay.
And actually, that's a good point to add on to, because when you're in a marriage, you're not only thinking about the increase in value of the business, you're also thinking about the liabilities. So a premarital agreement can also define what will happen to, say, the taxes that aren't paid on time, or any other liabilities that arise in business.
And in a startup business, how many times do we see somebody's trying to raise capital or get debt? The husband or the wife is the one that's running the business. The bank or the lender will say, we need your spouse to be a personal guarantee as well. And so there's multiple layers that, while we call it family law, and then there's the business side of things, they intersect quite a bit.
And so what about the spouse who is, they're going along, they're working with their business law attorney, having these well checks and trying to protect the growth. They don't have the premarital agreement that you were talking about, and they start to run into problems with the marriage, and they're not sure. They're kind of on the fence. Maybe they're headed towards a separation, but they're not quite sure about that yet. What are the options available to that business owner?
Well, I'll first state that financial issues are one of the leading causes to marital disputes. That's hands down, regardless if you have a business. If there is no premarital agreement in place, though, there is what we call a postnuptial agreement. It's similar to a premarital agreement, however, it is signed after the date of marriage. And I find that a postnuptial agreement can be a very valuable tool if the financial concerns and considerations are clouding the relationship between spouses. If we're able to remove that burden and the parties are able to agree what will happen to the business, for example, who will be responsible for the debts of the business, who will be entitled to receive the benefits of the business, we can define that in a postnuptial agreement, and hopefully that will remove the financial burden on the marriage so that the spouses can actually focus on each other again.
And how often is it? I mean, separation divorce is tough, right? And nobody wants to go down that road, but when you delay that process and there's a business involved, now employees are impacted, and I gather that the business is the greatest marital asset. And so when you delay that process, the business's valuation is going to drastically go down. So the quicker I think that you could get to who's going to control while we try and figure out everything is going to be the best for both parties. And how many times I've seen that they can't get to that. So coming to a common ground really helps obviously preserve one of the greatest marital assets.
And I think that's a good segue into talking about, from the perspective of, a business attorney versus a family law attorney, there might be different ways of looking at the word ownership. So from your perspective, there's certain bullet points that you need to hit, but from Teresa's perspective, she's looking at it in a different way.
Right.
And so in your mind, for someone who owns a business interest, what does that mean?
So ownership in a business is defined if you're a corporation via a stock certificate. You're a shareholder, you hold a stock certificate, an actual title to the ownership. If it's a limited liability company, you'll either have a membership interest which is evidenced in a capital account. It's essentially just what your percentages is in that company, or via membership unit is another term that's been used. So Title II ownership in a business is going to be outlined either through a stock certificate or one of the corporate documentations that I've talked about earlier. Now, business interest and business role are two separate. You might be the treasury secretary of your husband, wife's business, who they own wholly owned separately,
Right.
but they have a role, an officer director role in that company. They might not have any ownership, but they're going to have kind of that director role, which also would need to be addressed when a divorce or separation occurs.
And would a position like that, under most circumstances, give that person who's been designated as a treasurer or a secretary or something, would they have any right to come in and act on behalf of the business or make decisions, or is that just the principal owner?
So it would depend on the corporation, if it's or the company, I should say, if it's a limited liability company or the corporation. Limited liability company is going to be either run by the members or by the managers, and that's going to be outlined in the operating agreement. In the shareholder agreement or partnership agreement, those functions of the officer director role will outline what powers they may have.
Okay, and then Teresa, from the way that you're looking at this when you're meeting with a client who may have an ownership interest in a business, how are you talking with them about the ownership interest? Because I think most of those clients have the question of, do I need to give my spouse, am I going to lose my business? Do I need to give my spouse part of this business? And how do I go about figuring that out? Walk us through the steps of what you talk with that client about.
Well, first and foremost, it really is a determination of classification first and foremost, which has to do with when was the stock, for example, obtained, or when was the membership interest obtained. If it was obtained prior to the date of marriage, generally that interest in the business will be separate property. However, a marital interest could attach to that separate property depending on how the value or even the liabilities have increased during the marriage itself. If it's after the date of separate or date of marriage, then the stock certificate or the membership interest will be considered marital property. And even if that interest is in only one spouse's name, it will be considered marital property subject to generally an equal distribution between both spouses. So that's not to say that the business owner can't keep the business, but that business owner may have to buy out the other spouse to account for that marital property.
And so when we were looking at talking them through that process, we're looking at classification, valuation of that asset, and then ultimately whatever the distribution would be.
Exactly.
So how do they work on that middle piece? You know, we talk about classification and was it acquired prior to or after the marriage, and deciding whether it's a separate interest or a marital interest. How do they work on that valuation piece?
Well, the valuation piece can be very tricky. Generally, we would recommend that they not only involve a business attorney to take a look at all the legal documents, but also to get a professional, what we call a business valuator. There are multiple ways to value business, and it also depends on the type of business. If you have a business that has a lot of assets, then that's valued one way. That's different than, say, if the business is mainly a service type interest, such as a law firm or a doctor's office. And then once we get that business valuator in hand, then we go through the process of getting all the documents, getting all the information necessary to perform that valuation.
Can the parties agree on a value without having a business valuation?
They sure can. I always like to say parties can agree to anything when they're going through a separation or divorce. And honestly, that usually keeps things amicable and a lot easier to go through the process. I generally advise, though, that we at least get some type of guiding direction by involving a professional, just to make sure we're all on the same page.
Right. And so, John, when we get to the piece about distribution, you know, I think this might be where a business attorney could definitely be helpful, because, you know, Teresa's worked with them on the valuation part of the case, and then maybe the value that the valuation expert has produced is more than maybe what either party was expecting, and particularly the person who owns the business. So structuring the payment,
Yep.
you know, is that something that you could look at with how the business operates and the structure of the finances to help Teresa
Definitely.
craft something?
Yeah, and I know we worked a lot on cases together where Teresa comes in and says, here's a separation agreement, and it provides for X to be distributed as follows. Depending upon how that looks, is it whether they're buying the stock or whether they're just buying the assets of the entity, and then the payment that's structured out over those transactional documents would be outlined there. Based upon what the payment is moving forward, because let's say if the value of the business is $1 million, some people don't really have, you know, $1 million just sitting in the bank, so you're gonna have to pay that over time. And so when that comes up, then well, you are considered essentially a creditor. And so you want to make sure that you're protecting yourself from, you know, being an unsecured or secured. So you want to get that personal comfort with getting an interest, somewhat like a mortgage or a car loan, in the actual collateral that would be being sold at that time. And so there's certain mechanisms that would need to be completed to ensure that you've got that protection. But yes, a lot of times the separation agreement outlines how it's going to work out, and then we can come in afterwards and give the kind of the belt and suspenders.
Okay, and so you're talking about a separation agreement, and Teresa, maybe explain the difference between the separation agreement and the postnup and the prenup.
So, of course, when you do separate, you can't always predict what business assets you'll have or property that you'll have. So the premarital agreement and the postnuptial agreement generally give the parties guidelines or certain paths to direct themselves. Now, the separation agreement, though, generally contemplates everything and has the specific numbers in hand. So separation agreement can be more specific on how the business is going to be operated, as well as the interest divided. Now, I will note that's also different than if we were to take a litigation route. The parties aren't able to agree in a separation agreement. In that route, unfortunately, then you at the whim of the courts, I like to say. We have very smart judges, but at the end of the day, no one knows your business better than you and possibly your spouse. So they don't know the specifics, and that's when we'll have to introduce to a judge the details of your business.
The postnuptial agreement is something that the parties would be executing if they're simply thinking about separation, but the separation agreement is more in line with having already made the decision to separate, and either right at the point of separating or after the separation has occurred where the parties are no longer living together.
Yeah. Right.
Okay. And John, you talked a little bit about maybe collateral documents, kind of bumping up to Teresa's discussion of the separation agreement. Do you find that sometimes, as we were discussing earlier, that sometimes a spouse will designate the other spouse as a certain role within the business, whether or not they're actually doing that function? Is that something that also needs to get cleaned up?
Yes, definitely. For example, let's say they're both on the bank account of the corporation or company.
Good point.
Yeah, let's make sure that we remove the one that's no longer going to be in control. Whether they have ownership or not, if they have that treasury secretary, office director position with the company, they're on the bank account. How many times did you see that the one person cleans it? So you want to make sure that you've got a corporate resignation. That's a pretty simple document.
Corporate credit cards.
Yep, all of that. And any kind of finances that the one individual is completely separated and removed from those financial accounts.
And so those collateral documents, like assignments of interest and things, you help prepare in addition to the separation agreement to close out all of those. That's correct, yeah. Loose ends.
And typically the way I would see it is the separation agreement provides for how it's to occur, and then the transactional documents, the assignment, the asset purchase, the buyout, stock purchase, that's kind of the materializing of the agreement between the parties that's outlined in the separation agreement.
So you come in and help effectuate what Teresa has helped them
exactly
carve out as an agreement. And so what I think I'm hearing as we try to tie this all together is that it really all relates back to planning. At whatever stage we find ourselves, whether you do it as a prenuptial agreement or a postnuptial or a separation agreement, and hopefully if you're forming a business, you've had a business attorney along the way. But it's all about planning, and I would think that maintaining good records along the way really plays into that. So from each of your perspectives, why would that be important?
Just in my tenure as a practicing attorney, clients have paid legal fees, and those bills have been much higher when they're not proactive. They're not following corporate formalities, not keeping good records, not doing those well checks. They would save exponentially so much less. They would pay attorneys so much less, but we just don't think of that because like we talked about, I mean, hiring an attorney is a luxury. And so, most people I know don't want to sit down with us, but it's kind of the well check. Just like your body, you got to do the well check for your marriage and for your business. And it's just going to save headache and finances down the road.
Mm-hmm. Okay, and Teresa?
I would say in particular, because we're looking at the concept of marriage, that organization is key. And I am talking from before day one. For example, if we need to go through the property and figure out if there is any separate property that existed prior to the date of marriage, I'm going to need those documents. I'm going to need to see what the value of the business, of the amounts on the credit cards, the amounts that have been paid to the IRS regarding that business from before the date of marriage. And then through the date of marriage, if there has been an increase in the value of the business due to active efforts, especially from the non-ownership spouse if that exists, then I want to see what that increase was, when it occurred. Is there any passive increase then on the active increase in the value? Because even if you have a bank account with a certain amount, if it increases in value due to marital efforts or during the marriage, it could also be marital property subject to distribution. And then finally, when we get to the date of separation numbers are kind of like your frozen in time numbers. We look at those numbers primarily to figure out what assets go where. So I need to know what is in that bank account, what is in that credit card account on that specific date of separation. And if I don't have those documents, like John said, I spend a lot of time with my clients trying to get those documents. If I don't know the numbers, I can't help you divide the property.
And do you feel like business owners maybe have a little bit more scrutiny from the court because of the control that they have? So if the records are not adequate, then maybe a judge is drawing a negative inference from that.
I will say, I like to say judges tend to be, have their radars up, and they're looking for someone who's lying. They're looking for someone who isn't completely honest. And if you don't have your records organized, it can make it seem like you're trying to hide something. And through the litigation process in particular, everything is going to be disclosed beforehand. There is a full disclosure requirement if it's requested. And if you have, too many accounts going to nowhere, it's going to seem suspicious, and that can negatively impact you at the end.
So it sounds like you're both saying, not only from just helping the final outcome of your case, but also from a cost perspective, it really makes sense to be doing a good job with these well checks along the way and making sure your records are up to date. Otherwise, you're just going to incur more costs as a result of that. So Allie, do you have any questions that you want to throw our way?
Yes, actually, I think this is a really good question, and thanks you guys. I think I even learned a few things today, which you would think eventually I would catch up, but no. So this question, and it's directed to all three of you guys. It says, if you could give a business owner one tip about what to consider when getting married or facing divorce, what would it be? And Teresa, why don't we start with you, and then we can just work around.
I would actually bring us back to that last point we're just talking about. Keep your items organized. And especially for business owners, try to differentiate between your personal and your business financial situations. I've seen it before where someone receives payment on a service or a job, and they take the money and put it directly into their personal account. Well, then that has negative implications for possible tax purposes or property purposes, or if you do get married or divorced, family law purposes. So you want to keep everything organized, separated, and tracked. I will also add, make sure your taxes are paid. It's never good to see those go unpaid, and that goes back to the documentation.
I would say make sure you're communicating really well with your attorney about the decisions you're making, because I think being able to make informed decisions is invaluable. And you're not looking to the attorney to make the decision for you. You're looking to the attorney to explain to you, if I make this decision, if I engage in this transaction, what are the consequences and how can that affect me? How can that affect the division of my business? How might this particular transaction or this particular buyout affect the valuation? So I think having that high level of communication with your attorney so they can say, if you do this, then this could potentially happen. And that way, when you go into making those decisions, then you can say, okay, I knew exactly where this was leading me, and this was the route that I wanted to take.
Mm-hmm. We can't make decisions for clients, right? How many times do they say, well, what would you do? Well, we can't do that. We can inform you on the risks associated with each path that you may take. Mm-hmm. And I think just kind of echo what both of you have said is, hear what we're saying, trust our advice, and then make the best decision for the time being. And then on top of that, if you want to maximize the value of your corporation, you have to have proper corporate records. If you don't, you're not going to get the value that you worked so hard for. On the flip side, if the business needs to get restructured, you also need proper corporate records, because you're just not going to be able to do that. It just creates more roadblocks at a later time.
Awesome, and I think that's all great advice. For the sake of time, we are going to wrap up here. You can always contact us. You're getting ready to say goodbye to the guys. We're going to take you over to a screen so you can see how you can contact us and learn a little bit more about Sodoma Law. First, I would like to say thanks to all of you. Do you want to wave? Because you're getting ready to go goodbye on the screen. Okay, and then here we go. So coming up, what you'll see on your screen now is our upcoming webinars. These will run through November. In May, we are going to be addressing divorce, what to expect. In June, we're going to be talking about prenuptials, postnuptials, and beyond. And in July, we're going to be talking about making the decision to divorce. Is divorce right for you? So take some time to look at these, write them down, and additionally, you can connect with us here, and we are going to end on that note with a great video from Nicole Sodoma talking a little bit more about Sodoma Law as we wrap up with our contact information. Or the video is not going to work, but we have it on our YouTube channel, which you can subscribe to, and that's actually where all of these webinars are going to be. So if you need to connect with us, you can find us on the website, sodomalaw.com. If you would like to talk to one of the attorneys that you saw today, you can find us at 704-442-0000. Additionally, we're always available via email at attorney@sodomalaw.com, and also on all of our social media. The link will be in our video description after the fact, and you can also go on our website and you'll be able to find it there as well. And I think that's all for today. We've wrapped up. We've got all the questions. You know how to connect with us. And if we don't see you before, we look forward to seeing you all again in May.